Welcome to part 4 of the Basic Construction Law series on contract formation and negotiation. This last part of this series will discuss the importance of defining your scope of work on a contract. When you're talking about litigation or arbitration as it relates to construction, the vast amount of it is because of scope of work problems. Okay, let's say you haven't been paid everything that you are entitled to on a project, or you believe you're entitled to on a project. You believe you have extras or claims or change orders that should be paid by the owner. And the owner says, no, I'm not going to pay you that because that's part of the original contract price. That's really a dispute over scope of work. They're saying that your original scope of work included that extra work. You're saying it did not. Okay? So one of the key things to do is take the time up front to adequately address your scope of work. Talk about what you're going to do, how you're going to do it, and a good way, a practice point or a good thing to do is reference the particular plan sheets that you're going to be doing. So for example, if you're doing A1 through A10, say scope of work is defined as blank, as more specifically described in plans A1 through A10, okay? Or reference a project manual or a spec book. Okay? If you don't have anything that particular, then you want to be as specific as possible about not only what you're going to do, but what you're not going to do. Okay? Are you designing any portion of the project or contributing to design? If not, say it. Say you're not going to do it. Who is coordinating other prime contractors on the project or other subcontractors? If you're not, make sure you say it. Okay? If replacing bad decking on a roof is an additional cost, make sure that that's referenced. Okay? Be as specific as you possibly can, and that way you won't have ambiguities that can later be construed against you, especially if an owner is trying to avoid making payment on additional claims. So that's something to keep in mind. That concludes the Basic Construction Law series on contract formation and negotiation. If you have any questions about any of these videos, please feel free to contact me at the information contained at the end. Thank you.